Bonjour et bienvenue. Thank you for attending our virtual meeting of the CPATA Board of Directors. I now call the meeting to order. If you wish to listen to today's meeting in French, you can access the simultaneous interpretation by clicking the globe icon in the bottom of your window and selecting your language. CPATA is the Canadian federal regulator of patent agents and trademark agents, with staff and licensees living and working throughout our vast and free nation. I'd like to begin by acknowledging the land we call Canada as the traditional and ancestral territory of many Indigenous peoples, people who have lived on and cared for these lands for generations. Today, we are gathered in Ottawa on the unceded, unsurrendered territory of the Anishinaabe Algonquin Nation. We're grateful for the traditional knowledge keepers and elders who are still with us and for those who have gone before us. We respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our communities. Yesterday, CPATA held its annual general meeting where we presented highlights from our 2024 annual report and financial statements. As always, we appreciate the opportunity to share our milestones and priorities and to engage with licensees and other stakeholders. We were pleased to see our colleagues from CIPO, ICED, IPIC, and other institutions either in person or online. We also enjoyed hearing from stakeholders during the Q&A period and our reception. This is an invaluable opportunity for us to connect with others who have the best interests of the Canadian IP ecosystem in mind. Thank you to everyone who attended. The mandate of 2 elected directors ended and 2 new elected directors joined the board as of yesterday's AGM. We'd like to thank our colleagues Andrew Currier and Bridget Chan, who have contributed so much to the college. We're grateful for the expertise, insight, and passion for the professions that they brought, and we wish them all the best in their professional and personal endeavors. We're pleased to welcome Anne Abigail Fils-Aimé and Dennis Haskell to their first CPATA board meeting. Welcome, Anne Abigail. It's so nice to have you here in person. Dennis is on a trip that was scheduled long before his election. He'll try to join remotely, but I don't think he can. Judah, I think Dennis is biking how many kilometers today?
Yeah, we should definitely embarrass him in public. He's going 155 kilometers on a lifelong sort of dream trip. Also 155K today in the rain, facing headwinds is one man's joy, and we'll leave it at that.
Exactly. So Dennis, we wish you well, and we really are excited to meet you in person when you can join us. Today, we're also fortunate to be joined by the chairs of some of CPATA's regulatory and governance committees. These committees play a vital role in CPATA's regulatory initiatives. A warm welcome to Kristen Dangerfield, Chair of the Investigations Committee, Marcel Mongeon, Chair of the Discipline Committee, Bob Plamondon, Chair of the Audit and Risk Committee. And we have Mark. Who else do we have here? Yeah, I don't have Mark on my list, but I see him right there. So if we could, Mark Pioro, thank you so much for joining us as well. Thank you all for your leadership in fulfilling our regulatory mandate. We look forward to hearing from you during the meeting. We felt it important to take a moment for a word of warning about the scam that's targeting IP rights holders in Canada. Throughout 2024 and continuing into 2025, members of the public have been targeted in phishing attempts by fraudulent individuals and companies urging action and requesting payments to prevent threats to their intellectual property. These frauds are highly sophisticated and agile. They craft messages and websites that appear legitimate. They've even appropriated the names of actual licensees and lawyers. CPATA aggressively responded to protect those targeted. To date, the college has received and responded to over 350 expressions of concern. Such work is crucial to protecting the public, and CPATA remains committed to diligently doing all we can to prevent IP rights holders from falling prey. And now let's turn to today's meeting. Board meeting materials are published on the website in both English and French, where they're accessible to the public prior to the meeting. Recordings of each meeting are also available on the website. I'll begin our meeting by asking directors to declare if they have any conflicts regarding matters on the agenda. There will be some decisions around appointments, so various directors, including myself, will declare conflicts in those areas and excuse themselves from the proceedings. So I'll just look around the table for anyone to declare any conflicts. So Scott, I think you're going to declare a conflict and recuse yourself at.
Yes.
Yes, perfect. Thank you. At the right opportunity. And Steve, Steve Garland, you'll also recuse yourself at the right opportunity, as will I. Are there any other conflicts to declare? All right. Well, thank you. With conflicts now declared and minuted, would someone please move to adopt the agenda? The motion is, be it resolved that the agenda for the June 5th, 2025 meeting of CPATA's Board of Directors be adopted. Iris, I saw out of the corner of my eye that you are making that motion. Do I have a seconder? Scott, thank you. All in favor? Any opposed? That motion is carried. All right, now we will go right into the rest of the meeting. Now, with the agenda being approved, I'm not making it to the agenda. There's no addition or deletion. I'm just going to reorder here a little bit. Instead of going right into one of the election pieces, we're going to do the approval of the minutes because that's a nice housekeeping item for us to check off at this point. The motion, be it resolved that the minutes of the March 24, 2025 board meeting are approved. Could I have someone make that motion so it's on the table? Karima, thank you. Can I have a seconder? Amber, thank you. Before I call for a vote on that motion, is there any discussion around the minutes of March 2024? Okay, looking around the table. I'm not seeing any discussion, so I'll call for a vote. All in favor? Any opposed? All right, that motion is also carried. So the next item on our agenda is election of the Board of Directors and the committee appointments. So Tom Conway, the chair of our governance committee, will be speaking to this and then making some motions. So Tom, should the three people who are involved in this all leave at this point, would you suggest? It's yours. Yeah.
I can just take over for the purposes of making the motion, and then once you folks come back in, assuming the motion's passed, then you will resume the chair.
Perfect. So the three of us will leave.
That would
at
be
this
my
point.
recommendation to the
That's
chair.
what I think too. Okay, thank you so much.
So now is my opportunity to overthrow the government. No, we do, as you know, the governance committee has the responsibility of making recommendations to the board for the appointments to committees. We have two vacancies, one on the governance committee and one on the risk and audit committee. And we also have to renew the chair's position, the chair of the board. And so we have, you will see in your materials that there are motions to that effect. The candidates for these, the recommended appointments have exited the room because it wouldn't be appropriate for them to participate in the discussion or in the vote. And I think what we should do is have Judah read the motion, and then we can open it up for, we'll need obviously a mover and a seconder, and then if there's any discussion, we can have the discussion and then take the vote. That's the way we should proceed. Judah, could you read the motions, please?
Thank you, Tom. The motions are be it resolved that Ruth McHugh be reappointed as Chair of CPATA's Board of Directors until the annual general meeting in 2027. Should Ruth McHugh's term of office not be extended by the minister, the board will appoint a new chair at the earliest opportunity. And be it resolved that Scott Jolliffe be appointed to the Audit and Risk Committee and that Steve Garland be appointed to the Governance Committee until the annual general meeting in 2027.
We should probably take the vote one at a time, but first of all, I would ask if there's any discussion on the three motions that are on the table. Okay, so shall we take the vote on the first motion then, on the first resolution rather?
So that's the resolution for Ruth McHugh as chair till the AGM in 2027.
So we need a mover and a seconder. Karima's moving.
Second.
Iris is seconding it. All in favor?
All in favor.
Carried unanimously. The second resolution.
This is for Scott Jolliffe's appointment to the Audit and Risk Committee until the AGM 2027.
So I think we can have the same movers and seconders. So Karima moving, Iris seconding. All in favor? Carried unanimously. And the third resolution.
That Steve Garland be appointed to the Governance Committee until the AGM 2027.
Same movers and seconders. Karima moving, Iris seconding. All in favor? Carried unanimously. We would like to thank you for your service. Thank you. Over to you, Madam Chair.
Well, thanks very much, Tom. And I'm glad you referred to me as Madam Chair. I guess that's good news. So that's awesome. Thank you so much. The next section of our agenda is committee and reports. And it's so exciting to have people reporting in person today. That's going to be fantastic. So the purpose of this section is that our committees play a vital role in our regulatory initiatives. Each committee has a unique function as described in the reports, and to consider committee recommendations presented to the board from time to time for approval and to otherwise meet our fiduciary oversight duties, the board receives regular reports from each of its committees. So we are going to start with the Investigations Committee. So Chris Dangerfield, Committee Chair, over to you.
Thank you, Ruth. And good morning, everyone. And thank you so much for having me here this morning. It's really a pleasure to be here. And I'd particularly like to thank the board for inviting all the committee chairs to join you in your meetings over the last couple of days, because in addition to enjoying the camaraderie, it's really nice to be able to look at the important work that you're doing here at CPATA in a broader context than what we're doing on our individual committees. So you have my report in your materials, and I'm happy to answer any questions that you might have, but I thought I'd make a few brief comments about the work of the Investigations Committee. You can see from my report that we've not actually been overwhelmingly busy at our committee table. And the reason for that is that there are not actually that many matters that are referred to the Investigations Committee. And I think we heard from Victoria yesterday that the vast majority of conduct inquiries or ethics inquiries that come into CPATA are resolved informally with alternate dispute mechanisms. And that's fantastic. That is actually the goal of an effective public interest regulator, to have concerns that are raised by clients resolved in an informal, effective, efficient basis. And that's to the benefit of the members of the public that are being served by trademark and patent agents, and of course the agents themselves, rather than engaging in a complicated process. So job well done on that. When a complaint is brought to our attention, we need to consider whether there are reasonable grounds to believe that an agent has engaged in professional misconduct or is incompetent. We're provided with a significant amount of information at that point in time. It will include the original complaint. It will include the response from the licensee to that complaint. There may be other communications back and forth between CPATA and the complainant and the licensee. There may be additional documentary. There, in fact, there inevitably is a lot of documentary material that we see. And there is a preliminary analysis of code provisions. Does it appear that there are some breaches of the code of conduct that have been established by CPATA? Generally, we have a lot of questions at that stage. We've got a large committee. There are now 8 of us, and we are a mix of non-licensees and licensees, trademark agents, patent agents as well. So we have a very robust discussion about the materials that are provided. And if after we have engaged in that process, we're satisfied that there's a reasonable basis to believe there could be professional misconduct, then we determine that there ought to be an investigation. And generally speaking, in those circumstances, that would require some further investigation beyond what we've just looked at in terms of that preliminary analysis, so that we would retain an investigator, we would determine the scope of the investigation, and we would send them on their way and wait until we have received that report. Might take some time to get that report because usually this will involve interviews of parties, interviews of witnesses, obtaining more documentation, a lot of back and forth. And so there can be some time associated with that. And then when it comes back to us to consider again, we will review the original materials that were provided to us, the subsequent report, and then we have to consider whether there in fact is sufficient evidence of misconduct or conduct unbecoming that we ought to refer it to the discipline committee. And we really have very little latitude in that respect. If we're satisfied that there's professional misconduct, then we must refer it to the discipline committee. That's what the legislation requires. And I can tell you that the decision to refer a matter to discipline is not something that the committee takes lightly. It has significant consequences to licensees and to the members of the public that are engaged in the process as well. So we consider that very carefully. We, in the early days of the committee, we developed a number of policies, one of which is a decision-making threshold policy that we look at it, and what it does is provide us with a guideline and factors to consider in determining whether a matter ought to, whether a matter ought to be referred to the discipline committee because it amounts to professional misconduct. So we would look at the seriousness of the conduct that is the subject of the complaint. We look at the motivations of the member. We would look at the member's history. Do they have a number of complaints that have come in prior to this? What is the member's response to the complaint? Do they get it? Or are they oblivious to what the concerns are that have been raised? And we look at the public interest, because at the end of the day, the role of the committee and CPATA's public interest mandate is to ensure that services are delivered by trademark and patent agents that are competent and ethical. So the public interest will always be a factor when we go through that analysis. And so, as I say, if we're satisfied there's professional misconduct, it goes on to discipline. If the committee is not satisfied that there's sufficient evidence, so if it doesn't meet that threshold test that we've established, then in those circumstances, we must dismiss the complaint. Again, very little flexibility provided for in the legislation. The one additional piece that we are able to do on a dismissal is in circumstances where we feel a licensee would benefit from some advice or direction around practice standards, we will include that in the communication with the licensee where we dismiss the complaint. And ultimately, you hope that that achieves the purpose and that we never hear a concern about that particular licensee again. Our committee is continuing to grow. As I said, we're currently 8. We started out at 5, and we're continuing to evolve as we receive more complaints over the course of time. And that will continue, of course, as CPATA becomes more and more well-known in the community and within the public. And we're continuing to evolve as we are presented with unique and different regulatory issues that are inevitable in the context of a disciplinary process. And so we're learning and we're adapting and developing, and I have an incredibly conscientious, engaged, enthusiastic group of people on the committee that are doing really good work. So I'm grateful for that. And in addition to the policies that we've developed around decision-making and conducting investigations, we also have tremendous support from CPATA under the leadership of Judah, who we are very grateful for the provision to us of training, the ability to retain outside experts, subject matter experts, because even though we have agents on our committee, depending upon the nature of the complaint, the content may be very unique. And so we're able to retain the people that we need to assist us in going through that process. And then we have some fantastic staff support, Victoria and Vicky and Judah. So I'd like to thank you all for that, and thank the board for enabling that as well. So that is my report, subject to any questions you might have.
Thanks very much, Chris. That was an excellent report. The floor is open for questions for Chris, if there are any. Scott?
Well, thanks very much, Chris, and it's a pleasure to meet you and get to know you. And I certainly have a very high regard for your work and the importance of your committee. The only question that's or point that's been raised with me, and I raised it with Judah earlier, was making public the name of the individual about whom a complaint has been raised. And as I understand the process, there is no the name of the individual and the complaint is not made public unless there is a finding of misconduct. Is that understanding correct?
So the publication of the name of a licensee occurs at the time that a matter is referred to the discipline committee for consideration as part of our commitment to the open courts principle. So it's only after all those other levels that Chris took us through that an individual in our system would have their name open, and that there would be an open hearing for the discipline committee.
Okay. Thanks.
That's good, Scott. That answers your question, Scott. Yeah. Perfect. Thank you. Any other questions for Chris?
I was just going to ask you, from your vast experience in the legal profession, given the number of licensees that we currently have that are subject to the jurisdiction of the college, are the number of complaints that you have received, do they surprise you? Do you think, in your experience, how does it relate to, and maybe you can't answer that question, but I just want to get some sense of whether you think the number of complaints are more or less what you expected, greater than what you expected, or less?
That's a good question, Tom. And I don't know that I had really thought that through in terms of anticipating the amount of work that we would receive. But I think I saw yesterday that there is something like 2,200 licensees. Have I got that number correct? And I would compare that to a medium-sized law society that might receive something in the range of 400 to 500 complaints over the course of a year. Now, from that, you might end up with perhaps 10% of those going to a hearing, or maybe 7 to 10% of those going to a hearing. So the numbers here are quite low. But having said that, this process is really in its infancy. And so, you know, the first couple of years, you have to, I think, sort of build up the presence so that people have a comfort level with coming to the regulatory body. And then over the course of time, I think that will increase. Whether it will get to the stage of what you might see at a law society, I guess that remains to be seen. But what I'm prepared to say is the numbers are going to grow, and I suspect we're all going to get busier, but how much busier, I'm not so sure.
Well, thank you. Thank you for that.
Thanks very much. Any other comments or questions for Chris before we move to our next presenter? All right, seeing none, Chris, thank you so much for a great presentation. And again, thank you on behalf of all of us for the work that you and your committee do. It's really important and really appreciated. Yes, thanks so much. All right, our next committee chair is Marcel Mongeon, who is chair of our discipline committee. So over to you, Marcel.
Merci, Madame la Présidente, pour l'opportunité de vous donner mon rapport de la part du comité de discipline. Thank you very much, Madam Chair, for the opportunity to give you a report on behalf of the Discipline Committee. One of our challenges is, of course, workload. We can't anticipate how many people we'll need. I have a stable full of racehorses with no races to run. That's fine. That's not my job to worry about. But over the course of the last year, it has caused us to lose 2 of our public members, likely. Just in informal conversations with departing members appointed to the Discipline Committee, they said, but we don't ultimately do anything except meet quarterly. Despite, the reality is we've had 4 hearings. They are extremely important to the work of the college. The hearings absolutely take place in public setting, YouTube. We hold the hearings by Zoom, which is then fed to YouTube. It is not recorded on YouTube. They are not to be recorded. Are there technical means for somebody to keep a surreptitious recording? Of course there are. Much in the same way that anybody online today could be recording this meeting without our knowledge, but we don't need to police that. I'm proud that our discipline committee and the panels we've been able to create have had both experienced case conferences or the pre-hearing process, which are managed by one person who is experienced in having run hearings that are then passed off to a 3-person panel, which are again chaired by someone who is experienced in running hearings and will also have at all times at least 1 member of the college as a member of those panels. There's a certain juggling that takes place to ensure that there are, an appropriate number of people to put the panels together. Hearings have taken place in both official languages. Court reporters are present. We bluntly have been lucky in the sense that the hearings we have had up to now have, although some of the responding members have been difficult, they have not been wildly contentious. By the time the hearings take place, in fact, there's usually some agreement with respect to some joint submissions that are going to be made with respect to the facts underlying the case and potential penalties. And of course, it's up to the panel to decide, is that within the different legal rules appropriate for us. One of the things that we have had occasion to be able to do in this past year, thanks to work that we've done with the registrar and CEO, we now, as a committee have available to us independent legal counsel just to the committee. One of the concerns, of course, we all should always have is, are we acting in as cost efficient a manner as possible? And, you know, when this party has a lawyer and this party has a lawyer, and they're both effectively the, you know, different arms of the same college, one wonders why we need separate lawyers. Well, it's because we're proud of the very independent discipline process we have. I can absolutely, on your part and the part of my committee, say that we have adopted, as we understand them, the best practices for discipline committees. We have an independent process assisted by appropriate resources. We have conducted appropriate hearings up to now and look forward to the future. We've been working on we continue on a quarterly basis to meet and work on our policy frameworks. We have just recently adopted in principle a request to admit policy, which could make contentious hearings more effective in that parties are asked to agree to obvious facts ahead of the hearings. In addition, we're working on other appropriate policies for work that may or may not be asked of us. So, for example, one of the policies we're currently working on is what would be our process if the investigations committee had made an interim order, particularly with respect to suspension of a member, and that member wished the discipline committee to review that. What should be our policy framework? So, of course, we don't have those situations right now, but when we do, we want to have the policy framework in place. So, subject to any questions that members of the board or other attendees have, that's my report with my thanks.
Thanks very much, Marcel. That was a great report. Are there any questions or comments from your colleagues around the table? Scott?
Thanks, and thank you very much, Marcel. Also a pleasure to get to meet and know you. One issue that keeps coming up, expressions to me on the part of licensees is, and I've raised this with you, is the use of YouTube as the platform for public participate, or at least attendance at discipline committee hearings. I guess and it's been I've been told that this is a process and procedure that is determined by the discipline committee. And I'm sure you've spent a lot of time going over it and the rationale for it, but it is seen by many, YouTube is seen by many as being a rather unprofessional and potentially uncontrollable platform. And whereas on the other hand, our courts, the federal court and other courts in Canada, use a different platform for public attendance at their hearings, such as Zoom and other platforms that at least are seen to be more controllable. Is this something that you and the committee have considered? And it's not a question of a real threat, but a perceived threat to the process.
It's an excellent question, and I'll be blunt. The YouTube was initially my personal recommendation to the committee to adopt for the following reasons. One, I'm frugal. It has a great cost available to us. It doesn't cost us anything to instantly broadcast from Zoom to YouTube. Secondly, the advantage of we take the Zoom feed. So our hearing actually happens on Zoom, but we press the magic button, or somebody presses the magic button, and it immediately gets broadcast out to YouTube, again, for free. I can appreciate wanting to say to people, well, why don't you come into the Zoom meeting? But now that starts requiring decisions in Zoom to be made. So this meeting is actually being broadcast out using something called the webinar feature. And part of the problem with the webinar feature is we can't do those breakout rooms, which are so critical for a hearing process. Gee, could we have an off-the-record discussion? Want to get them into breakout rooms, and you can't do that with Zoom webinar. There are, bespoke software platforms that could do anything we wanted to that would have the appearance of professionalism. And I mentioned appearance of professionalism for a reason. Curiously, in the United States, federal courts of appeal, federal courts, state courts of appeal, state courts all use YouTube broadcasts as their preferred platform to get hearings out into public. Of course, one of the other things that the discipline committee is vitally concerned about is the question that was posed yesterday afternoon at the AGM about, well, what about confidential information that's going to be disclosed? We're very sensitive to not only the need to make sure that nobody would lose intellectual property rights because of a potential public disclosure in a hearing, but we're also concerned about the identification of individuals, particularly clients and others who aren't accused of anything, who are just part of the story. So, for example, our writing style will refer to complainants or complainants with a letter if there are multiple complainants. And we'll take some other steps in that regard to anonymize the other parties to a process. So I hope that answers your question.
It does. And maybe you could help our public understand that YouTube is a resource that's used by Canadian courts. U.S. courts is one endorsement. It may not be the best in this context, but are there other Canadian courts that are using YouTube?
I am personally, this is a personal view, woefully shocked at how bad Canadian courts are at making access to online trials and other proceedings available online. I can go to the Texas State Court's webpage right now, and I can find you a list of every court that's online in Texas right now, and go and click and get the YouTube feed. If I wanted to find any court in, say, the province of Ontario or the federal court, I can write to the court or send an email to the court. They will say, well, why do you want this? And I think it's shocking, because that's not what the open courts principle stands for. The open courts principle stands for the principle that if I want to wander into a courtroom as a member of the Canadian public, to pick up the chair's phrase, in this vast and free nation, the rule of law thrives on the ability of somebody to go and see any court in operation, not those who know the magic 7 or 8 or 10-digit code to get into a Zoom meeting. And so in that regard, you're right. There aren't a lot of Canadian courts on YouTube, but I'm taking, we're taking our lead from a country, well, they used to have the rule of law at least.
That's great, Marcel. Thank you. Scott, I trust that.
Yeah, that's fine. I'm not sure it answers the concerns that exist in the public, but thank you. That's a great explanation. So thank you.
Well, I think one of the things that it does, Scott, is because this is a public meeting and this is a publicly accessible meeting, and this meeting is recorded and will be on our website, Marcel's excellent explanation is now available for anyone who wishes to hear it. So if any of us are getting that question, we can refer to this recording and any members of the public can hear directly from the chair on the rationale for what we've adopted here. So thank you, Marcel. Tom, I see that you've got a question.
It's not a question so much as just a comment on the exchange. I was recently involved as counsel in a class action. And at the beginning of the class action, the parties agreed to ask the judge to allow the proceedings of the court to be broadcast. Now, it wasn't on YouTube, but it was broadcast to all of the public, and every member of the class that we were representing had an opportunity to watch the proceedings, and they did. And the media took note. There were a number of articles published about how wonderful it was that the court was finally allowing this kind of access to the courts. So in terms of if that is any measure of the public interest, and I suggest it is, the more broadly we can make our proceedings known, whether it's through YouTube or through some other platform, I think we should applaud that effort. So I fully endorse the Disciplines Committee, not that they need my endorsement, but I certainly support them in their desire to publicize and make the proceedings freely available to as many people who care to see it. It is reassuring to know that they have adopted the same kinds of principles and approaches that the federal court applies, that the Superior Court applies, in keeping trade secrets, intellectual property matters confidential, and the names of informants, the names of complainants, and the names of witnesses, if that kind of information is sensitive and is not, and there's no public interest reason to disclose that information. So I fully support the efforts of the Discipline Committee and what they're attempting to do. So that's my 2 cents for what it's worth.
It's worth a lot. Thank you very much. All right, we're going to move on now to the next report. So, sorry, Arise, did you? Okay. Our registration committee chair, Mark Piaro, is here with us today. And welcome, Mark, and we look forward to your report. Over to you.
Thank you, Madam Chair. Good morning, members of the board and colleagues. The report is in your package, which is available online also. Please feel free to answer any questions that are arising from that. If I may take this opportunity of meeting in person to share a few brief reflections on the work of CPATA's registration committee. Over the past several years, the committee has impartially adjudicated disagreements with registration decisions of the registrar, reviewed registration policy, reviewed CPATA registration practices to promote fairness, made recommendations to the board regarding competency profiles for the professions, and approved standards or cutoffs for the exams. My professional background is as a lawyer working in health profession regulation. As a very brief aside, at least some have used YouTube to live stream discipline hearings with appropriate precautions such as pre-registration or unique links. But moving on from that, from my perspective, I'm impressed with CPATA's work as a modern best practice public interest professional regulator. To give a couple of examples, and Chris touched on these a little bit. A majority of the committee are not licensees, which can promote public confidence in decisions of the college. At the same time, care is taken to ensure professional expertise is not lost, for example, through working groups, consultations, and agents who form part of the quorum at meetings. As another example, the committee's composition is separate from board composition, which helps ensure that the committee has an impartial, objective focus on its regulatory mandate. And to ensure accountability and effectiveness, the committee members are carefully selected, trained, and are guided by objective terms of reference, competencies, policy documents, and expert staff. So I hope these examples illustrate how CPATA is at the forefront of professional regulation. So with those remarks, I'd like to thank the board for the opportunity to serve on the registration committee, thank my colleagues on the committee for their diligent, insightful work, and thank staff for their excellent support.
Well, thank you, Mark. We are so grateful to you and to your committee for the great work that you do. The floor is now open for questions for our registration committee chair.
None from me, Madam Chair.
Okay, Scott. I think Mark's feelings are going to be hurt that you haven't asked him any questions. I'm sorry. I'm kidding. I'm kidding. Mark, thank
Well,
you.
I should say I did have an opportunity to speak to Mark more about the ability to get qualified people to serve on his committee. And he assured me there's a lot of interest and he doesn't have any trouble finding great people. So thanks, Mark, and thanks to your committee.
Thank you.
That's great. That's great. Thanks so much. All right. So the next report is from our governance committee, and our chair, Tom Conway, is going to take that report. Over to you, Tom.
Merci, Madame la Présidente. Il me fait plaisir de vous présenter le rapport du comité de gouvernance. It's my pleasure to present the governance committee report. I think I've been in the job as the chair for about a year, maybe or so. I took over from Karima Bawa, who really led that committee since the college's inception and did a marvelous job in laying the foundations. So the work we are doing now is building on that mandate or that legacy that she has left. And as is evident from the discussion this morning, she did a great job in setting out for us the right governance policies for right touch regulators. So I again want to compliment her on her pioneering work for the college. Now, I know some of you may think it's really ironic that somebody who has trouble governing his own personal life would be put in charge of the governance committee, but I'm not responsible for the decision. But what I will say is the committee is a very active committee. Our latest member, Bridget Chan, made a very significant contribution to the discussion as a licensee, with her perspective as a licensee, and as a very significant leader in her own IP law firm. And so I'd like to take this opportunity to thank her again for her contributions. She did not run for re-election, and so I think it's worth mentioning again in public and thank her for her tremendous contribution. And we all, I know, wish her well in the next phase of her very distinguished career as an IP professional. So just for purposes of our the members of the public, the governance committee is given its mandate under bylaw 40 of the college and bylaw 42, and its terms of reference is to examine governance practices, including board practices and performance, and makes recommendations to the board. And this includes the development of and amendments to the foundational governance documents for the college, including the Act, so any legislative changes that the college might be advocating to improve our ability to govern in the public interest, changes to the regulations that govern our internal workings, and changes to the bylaws. We also make recommendations to the board on nominations to committees, and indeed to the minister in terms of the kinds of skills that we would like to see on our board, and the election process. So we oversee the election processes as well. So by engaging in those activities, we endeavored to provide the board with recommendations on best practices for good modern professional regulation, and for the best people to fill the various positions that become vacant as we progress through time. So it's a very important committee, and I'm very proud to have had the opportunity, the privilege to lead that committee. This year we have met twice, once in February and again in April, and we continue to review, as I've reported in past board meetings, our own terms of reference to ensure that we get rid of any excess verbiage. That we ensure that what we're doing is focusing on what the college needs at the moment. And we continue to, so for example, we are continuing to work on and develop a CEO performance management and evaluation process for 2025, and indeed for the longer term. And we hope to be bringing that forward to the board for its consideration, hopefully sometime later this year. And we continue to be engaged with ongoing appointments, and you will know from the previous motions that our recommendations for the chair and committee appointments was adopted earlier today. So, subject to any questions that you may have, that's my report.
Thank you very much, Tom. Are there any questions or comments from our colleagues for the chair of our governance committee? And just a reminder, the report was included in the package, so I know you've all read it. All right.
Thank you, Madam.
Well, Tom, thank you very much for your report. We appreciate that. Next is the chair of the Audit and Risk Committee, Bob Plamondon, is with us this morning. And Bob, over to you. Thanks again for everything that you do in such an important committee. So thank you.
Madam Chair, it's a pleasure to be here this morning. The minutes for our previous meeting of May 15th are in your materials, but I'd like to take the time this morning to inform the board and members about the functioning of the committee, and to give you some insight into the diligence and thoroughness of our work on your behalf. I am the founding chair of this committee, so I've been here since day one. I think recently renewed, so I'm with you for a little while longer. I would say that among the many boards that I serve on, and audit committees and others that I chair, this is an exceptionally strong committee. So the team that is there is highly qualified, and we meet regularly. So it's not a, it's throughout the year, including in the summertime, we will be meeting. And so your board members, Idis is a member of the committee, and Andrew Courier, who just stepped down, was a licensee, and certainly brought with vigor and enthusiasm that perspective to the deliberations of the committee. So we're sad to see him go for the contributions that he made. We have Maureen Rogers, who's responsible for the weather in Canada. She runs the Weather Network. So and highly qualified on financial and other areas. And we're very happy to welcome our new member, Scott. I would say that Scott, someone, it looks like you are born curious. You'll fit well
with the committee members because we don't hesitate to ask questions and dig into details to make sure that we understand, all the particulars of the work of the committee. So welcome to the committee. We're exceptionally well supported by the CEO, Judah, and Sean. And I would say the packages that we received at every meeting are thorough and detailed. And it's a bit frustrating because every time I think I've got a question, the answer's right there. They're really anticipating every angle that might come up. So, and we meet with them, in committee, and we also meet with them in camera, including with Sean in camera. So, to maintain that independence of their role. So they've got direct lines and dotted lines, and to ensure the communication is there. We also review the work of the external auditors, Grant Thornton, and we meet with them in camera to ensure that the audit is proceeding following appropriate standards. And we try to keep their fees down as much as we can along the way. But a major portion of our work is ongoing financial oversight. So at every meeting, we are looking at the financial results, how they compare with our budget, how they compare with prior year. We examine variances to see, whether there's opportunities for saving money, or, to gain insight where there might be certain risks. We look at any major expenditure items to see if there's other alternatives where we can get either better service or savings. So this is a very thorough part of every single meeting that we do. And we're also looking at forecasts and projections to say, are we on track with our budget for the year? We want to do that just as our work, but also to reflect in our committee minutes if there is anything that we think you should know as a board, to give you a heads up on any issues, any mitigation measures that might be required. We also have responsibility for the treasury function, which wasn't really much of a challenge at the beginning because we didn't have any money. But now that we have accumulated some financial reserves, and because of the fluctuation just in straight cash flow, we get money at the beginning of the year and then we spend it over the course of the year. So we do have cash balances that we ensure are invested in accordance with policies, and we're looking for opportunities to ensure we get maximum return for those dollars while taking minimum risk. Essentially, when I say minimum risk, it's zero risk for now. That may be as the reserves accumulate in the years and we've got a little bit more visibility, we would, following extensive discussion and discussions with our banks and other potential investment opportunities, we would come to the board with a recommendation if we thought we would move away from what I consider to be a zero risk policy. I mean, I think our biggest decision is whether you would put the money in for 30 days, 60 days, 90 days type of thing. That's the order of decision now. But we have that responsibility, as well as I guess when I'm talking about financial oversight, we do a very thorough review of the year results to prepare the budget for approval by this board. So we're digging into the details. And one of the things that I'm proud of as the work of the committee is despite the fact that we have overperformed on a net basis, meaning we're coming to you with surpluses throughout the year, that even though we've had more on the revenue side than expenses, there has not been for a second a let up on the review of expenses. There hasn't been, okay, we're in strong position, maybe we can make some investments here. We stick very much to the budget and continue to look for opportunities to bolster those reserves and strengthen the financial condition of CPATA. So that's in our DNA. And I can see it is nodding because she's very much part of that. We also ensure at least from a tax point of view, regulatory compliance. So that should be of interest to board members. So if for any reason the statutory deductions for payroll were not met and Canada Revenue Agency said we were behind, the board is responsible for that personally. Now you have insurance and whatnot, but we have at every meeting, a compliance memo signed by the CEO and the CFO attesting to the fact that they have complied with all of the regulations, more than just on the tax side, but including even on official languages. We also have carriage over the risk management. So that is developing the risk framework, the risk register, assessing the likelihood and severity of different risks and what they mean, mitigation measures. And that is a constant work in progress as risks change over time. New risks emerge. The ratings change, and there are things that will always be high risk and get a lot of attention. So cybersecurity, for example, would be near the top of the list. Financial integrity has, in terms of financial conditions, probably come down on the risk register as we've now built up some reserves. Looking ahead, a major piece of work for this committee is evaluating the reserve policy. We had a policy in place, and I think our initial policy was, let's get some reserves, but we had nothing. And I think at that point, we didn't want to reach too much for the stars because we wanted it to be achievable and we wanted to make progress. We didn't want it to appear so daunting, and we were going through what was a major risk, which is the rise in the revenue and the fees. And there was some uncertainty around what the reaction was going to be. So we budgeted prudently. We budgeted with reserve, but we did put in the budget the accumulation of reserves. Now we've exceeded expectations. Now we have to have another look at it to determine what is not only the best practice, but the best practice for CPATA. We are unique in terms of the risks we take. I listened to the discipline committee. We could be hit with a major, a major case that would represent a significant financial burden and cost to CPATA. So we're doing a significant amount of work. Sean already has looked at the landscape of other regulators. I think you're over 40. I think you've looked at so far, but that doesn't mean we're just going to look for the average and with the insight that we have around the table, and certainly from Sean's expertise, we will come back to the board with a evidence base made for CPATA recommendation that would, I think, withstand rigor scrutiny and the curiosity of members and those who might be wanting to apply a certain amount of pressure to alter the fees if the reserves get too high. And of course, as a not-for-profit, they can't get too high because CRA would look at us and say you're just building up reserves for the sake of building up reserves, and you can't do that without attracting tax. So they have to be appropriate in the circumstance. So that's a major piece of work that we are in the midst of doing right now. That's my report. I'm happy to respond to any questions.
Bob, thank you. That was an excellent report. I'm going to look around the table and see if there are any questions from our colleagues. For you, you're going to wait and ask your questions in the meeting, Scott, right?
Well, I'll just say I'm delighted to have been elected to serve on your committee, and having seen your work over the last year, I have a huge amount of respect for your committee and of course for the work Sean does. So, but you can expect that I will be curious. I don't have an accounting background, but I've over the years taken a great interest on the sort of financial side of organizations. So I'm thrilled to join your committee.
So we welcome you, and it's good to have financial expertise on the committee. But it's good to have someone that just has a complete objective, independent point of view. Whenever I make presentations, I want to make sure they're understandable to all, and the materials are designed that way. But so welcome.
That's great. Thank you. And thanks again to you, Bob, for your exemplary work since the beginning. Thanks for sticking with us. It's been great. All right. Next up on our agenda is the report from the CEO. Over to you, Judah.
Thank you, Madam Chair, and thank you to all the committee chairs for these insightful reports that I think help the board and those watching and staff recognize just how much rowing happens to make sure that we're continuing to move through at times choppy waters, at times smooth ones, but relentlessly forward in the public interest. And we're grateful for all of the committee members' contributions. As the CEO today, I thought we would step back. We're about midway through the year, so I would provide a quick brief update on our annual plan. As you all know, we have a strategic plan, and then to advance it, we take it 1 year at a time, one step at a time. It's baby steps, baby steps. And so we have a budget, and following the budget, we develop an annual work plan. It's presented to the board in December of every year. So I thought I'd give you a midterm update. It's pretty high level, but the good news is we're on track and going well, and it's going smoothly. The highlights are at page 32 of the board materials, and we talked about many of these aspects yesterday at the AGM. Starting with an important, the activity plan is framed in a chart around the different aspects of our strategic plan. So starting with strategic and stakeholder engagement, we've been very busy. We've had meetings with many stakeholders. We have regular contact with ISED and CPO. We met with CPO's executive team just 2 days ago. And of course, the head of CPO attended our AGM, and we were grateful for his participation yesterday. We have been in touch with numerous other regulators around areas of shared responsibility. We continue to engage with IPIC and with various associations, including a trademark group out of Quebec, with INTA most recently, as we start to broaden our horizons somewhat as well, to understand the full ecosystem. We've also had excellent discussions both with IP regulators in other Commonwealth jurisdictions and in the United States, as well as with other regulatory organizations, including CNAR, where Jen Slobodkin recently presented, where our chair recently presented, and where I'll be presenting in the fall. So it's been a very busy time. One particular development that I'm also pleased to see is increased engagement with the IP ecosystem. We've been invited to conferences hosted by them, both in December and more recently. And we've also had direct engagement with numerous groups from the Innovation Asset Collective, IPON, Communitech, and others, and lots of interest in the work of the college and our efforts to facilitate access to competent professionals across the different industries that require the expert services of patent agents and trademark agents. Turning to the annual license report, I'm so pleased with the rollout and so grateful to the team who really rolled up. This was a very tight timeline to add a new annual new questions to an annual report. We consulted with the professions on them. We refined it. We took some questions out that were confusing, tuned some up, and really went for a right touch approach. We have some really interesting data as a result of the annual report. And we've had some positive feedback and worked with licensees to refine in real time on some of the questions where there might have been missing factors. For example, one person wrote to us and said, why is language X not on the list of available languages where you can serve the public? And we got to write back the next day, it is now. Go back in, answer it, no problem. And so we're agile and we're able to do those things, and we're going to be data informed and evidence-based increasingly by being able to engage with our licensees in such a proactive manner. Complaints and discipline, you're about to hear from our General Counsel, Victoria Reese, so I'm not going to go into that or unauthorized practice or the code education, but we've got good things coming and really pleased with where things have moved. Our competency profiles are now complete. They'll be evergreened over time, but let's give it a little bit of time to let the grass come in. But it's gone very well with the input of the professions throughout. And as we are going to hear, our pathways initiatives and our multi-year project to look at how people get into the professions is doing extremely well. And Jen will share some findings from our apprenticeship consultations that were held last year and that we analyzed through to today. Turning to the ongoing work, we have some policy development that will be coming later this year or early next year around return to active practice. For those who are inactive, there's a risk of skills degradation. So at what point does the regulator need to take note of that and be concerned? Operationally, we've been busy firming up our processes and systems and doing lots of training. I was very pleased that we had a day of mental health first aid training, which for frontline regulators is vital. We've had a crisis moment already. This happens in high stakes exams environments. Our staff need to be aware. Our staff need to be prepared. Our staff also are the front lines and take questions from a range of people in different levels of emotional distress at times around anything from my patent wasn't renewed to why is this letter from the regulator headed my way? And we recognize these are difficult moments for people and we wanted to prepare staff. So I was pleased to be a part of that training as well. Always healthy to think about mental health as well. Board and committees are running smoothly. I think we've heard from them, and I'm glad to hear that my perception is being confirmed by those who are doing the daily work. And our governance is continuing with regular meetings, public board meetings, and planning meetings that are ongoing. And so we are bottom line on pace. Working well through the final lap of this strategic plan while preparing and starting the swim for the next strategic plan. We'll be back to the board with more planning in the fall. We're going to use the summer to firm up some of the takeaways from our AGM and from our earlier sessions to take that to the next level, to bring it back for the board to craft and refine into shape. And so with that, I'm open to questions, but that's the report on how the year has gone so far.
Thanks very much, Judah. So the floor is open for any questions for Judah. Okay. Go ahead, Scott.
Thanks, Madam Chair. I'm not sure this is the right place to raise this, but I do want to raise it and perhaps have a discussion about it. But as I've expressed before, and I think others share this view, that the matter of client agent privilege is of existential interest, if not concern, to the public and to all of our publics, including, of course, the agents. I guess I'm not sure where we stand on that. We've had discussions, but I'm not sure those who are participating in this meeting really know where this matter stands. And finally, I'd like to suggest that the board consider appointing either through the governance committee or directly a task force or other small group to take on this issue, and working with you, Judah, to see if we can't make some serious progress.
So I'll just quickly address your point about do we need a task force or some other small group? So we will be addressing this important issue. We will continue to be addressing it. How we'll do that, the mechanics of that, we'll think about what's the best approach for that, Scott. And I think the right time for us to talk about all of that is at our strategic planning session. We had an original sort of a brainstorming session, I'm going to call it, a couple of months ago around the key pillars for our next strategic plan, which will take us through 2028. And so when we do the deeper dive on that coming up later this year, that'll be a good time to talk about the how. we'll get this done. But I'm going to also, hand it over to you, Judah, just to update on Scott's earlier comment on that.
To the point about where the college is at with
Yeah.
privilege, for anyone who is new to the issue, privilege was granted in part to patent agents and trademark agents before the regulator was created. And so it was an interesting development that happened on the expectation that a regulator would come into force, because a regulator is needed when there is privilege available to a client, so that if the client has any concerns about the operation of the professional's matters, or if there are complaints or issues that arise, there is a group that is able to conduct investigations and look at those materials. There have been some issues in the scope of the privilege since the inception of the college. And the college, since day one that I've been around anyway, and on our strategic plan, are committed to right-sizing the privilege to fit scope of practice on behalf of clients. This is really a client protection issue and an economic competitiveness issue for Canadian innovators. We've made this position known publicly, repeatedly, and we continue to engage with different groups, including the federal government, on these matters. How and where is more of an in-camera matter, but we continue to advance the public interest, and in this case, that includes working with partners to try to modernize the privilege that is still in its early stages, having only been granted to the professions in the 2000s, but we are seeking clarity and refinement so that it reflects the presence of a college.
Thanks very much, Judah. Are there other questions or comments for? Yes. Go ahead.
Yeah, if I could just add to Judah's comments from my perspective as someone who's been actively involved in the professional regulation of lawyers over the past well over a decade. Just an historical context here for the statutory privilege that the IP professionals now enjoy, the concern of the legal profession, and indeed the governments of the time, about extending privilege to intellectual property professionals was essentially that they were effectively not regulated. And there was no way of enforcing a statutory privilege effectively without professional regulation. So the creation of the college is and demonstrating that the college can effectively regulate IP professionals in the public interest is a precondition to the continuation of a strong statutory privilege for the protection of the clients of IP professionals. So that's just to give you a little bit of historical context. I think it's fair to say that with effective regulation of the intellectual property professionals, the concerns of the various law societies in protecting client rights has abated and will continue to abate, so that I think we may very well see the law societies taking a more positive approach to this, to the idea.
Thanks, Tom. Okay, that's great. I'm looking around the table for any other thoughts on the CEO report before I move us along to the next section of our agenda, which is program reports. So we've got the professional responsibility report. Victoria Reese, our general counsel and professional regulation. Over to you, Victoria.
Thank you, Madam Chair. I want to start by asking you all to visualize an iceberg. So what you've heard from the Investigations Committee and the Discipline Committee is the tip of the professional responsibility iceberg. And what's important to appreciate is that's the worst of it all. That you're seeing when agents go wrong. You're seeing when complaints are visible. And that is literally the top 20% of the iceberg. And so I wanted to just take a moment to highlight the framework for the professional regulation program, responsibility program. And it's important to note that throughout, from the bottom of the iceberg to the top, the approach is very much right touch, which is proportionate, principled, and proactive to the extent that it can be. And it focuses on education and early resolution. So when you ask some regulators to talk about their professional responsibility program, they'll jump to their complaints and discipline statistics. And for us, we're much prouder to talk about all of the foundational work that prevents things moving up the iceberg. So we focus on education, early resolution, and following best practices in administrative law and professional regulation to the extent, as Chris touched on, that we are allowed to under the Act. And so the foundation of the entire program is the Code of Professional Conduct for patent agents and trademark agents. And everything in the program is based on the rules and guidance that is provided in the code. And so we start with education around the code, and you've already heard about the extent to which we're trying to create recorded presentations about the foundations, and I really hope that soon you'll be able to all review these videos and learn something yourselves too. I think it's a very accessible way of making the code very live and practical. We also put out articles in the newsletter on a regular basis. So then the next piece of that is something other regulators don't often do, which is an ethics inquiry process. There are a number of regulators who feel that they're taking on too much responsibility for suggesting what somebody's professional judgment should be. But in our case, we'd rather help people understand how to apply the rules in the code to their actual scenarios and be the fence at the top of the mountain rather than the ambulance at the bottom. And so what I've been very impressed with is the nature and number and thoughtfulness of the ethics questions that come from our licensees. They're fascinating. I think Judah and I find it one of the most favorite parts of our work is wrestling with some of the really interesting ethical issues. Then you move up to the agent inquiry process, which is, again, a way for members of the public, licensees, even members of the government to contact us and say, I've got a problem, I've got a concern about a lawyer's conduct or an agent's conduct or both. And I want to know if this is something that you can help me with or if I should file a complaint. And so we get far more of those agent conduct inquiries than we do complaints. And we have had a high level of success of either resolving those or moving them on to another resource where it's not something we can handle. So then we move into the complaints process. And as Chris said, we get very few complaints. And I would say about 50% of the complaints that the committee deals with are either originally complaints or instigated or initiated by the committee itself. And so the number of complaints is fewer than half a dozen a year. And I'm used to being in an environment with 2,200 registrants where I'm dealing with 300 at a time. And so this is very low. You've already heard from the investigations committee and the discipline committee and what they do. They're at the very visible part of the iceberg. And then you've also heard a lot about the unauthorized practices regime. And the chair mentioned at the start the phishing scheme that we've been dealing with. But we also, it's important to note that we have, I guess, what we call an escalated approach to dealing with unauthorized practice. The first thing we do, we get a lot of unauthorized practice inquiries, and I consider every one on a very timely basis because there can be very risk associated for clients. And so I would, for example, usually it involves looking at the website and seeing what people are putting out about themselves, whether or not they're allowed to do what they say they're doing, whether their marketing is potentially misleading. And then I usually just engage and I start off in a very, hey, we're CPATA. Do you have any idea who we are? Let me just tell you what we do. And let me just suggest to you that maybe you want to modify, what's out there. so that you're not causing any confusion. And if I get a great response back, it's thank you very much, and I usually do. If I get no response, it's hey, here, listen. And sometimes I've gone as far as writing a very stern lawyerly letter. But I can tell you how really rewarding it's been, as I said yesterday, to engage with firms who are very quick to respond and say, sure, yeah, and then they'll send it back and say, how does this look? You know, are we good with that? So in this way, I think we're making a lot of progress in trying to help people understand the scope of what agents can and can't do and what they can market. To Chris's point earlier, this year in the first 5 months, we have seen a significant uptick in activity and professional regulation. And so basically the numbers for all of the categories have surpassed what we would normally have for a complete year. We've had 13 or 14 now ethics inquiries, 18 agent conduct inquiries, 4 complaints under investigation that have continued from 2024, 2 hearings carried over from 2024, and over 350 unauthorized practice matters. So despite this, the staffing for the PR program is very lean. It's me, and I'm part-time. I also have assistance from administrative staff when needed. And the registrar with me continues to very closely monitor the amount of activity to determine whether or not adequate resources are in place. But it's still so early. It feels so early. We can't even identify trends to be able to say we expect this many hours of work or that many complaints. I think it takes a full 5 years before you can really start to do that. And in terms of future activities, you've heard about, you know, more code education. Complaint activity is highly unpredictable. Plans are underway to create a much more robust data tracking program to be able to have dashboards and trend information, and complaint file and information management. And we're working on developing practice management resources that will help agents be able to access these resources in a self-sufficient way. So happy to take any questions.
That was an excellent report, and thanks for the analogy and your super informative way of telling us how you escalate complaints with people. That's pretty fun, Victoria. You're amazing. Any questions or thoughts? Yes, Scott.
I can't let you go, Victoria, without a question. First, I admire the work that you and your group are doing. And I mean, it's a tremendous load that you have undertaken and execute very well. My question is really around one word, and you mentioned that's lean. You have a very efficient and lean team. And I'm just wondering, with all of the responsibilities that you and your team are carrying, do you have enough resources?
Overall, yes. And I say overall because it goes like a roller coaster. And so what's been particularly helpful in the last literally month is that I have some extra external administrative assistance on the unauthorized practices matters, which were literally taking hours of my time, and it's really not the best use of my time overall. And so that's made a big difference. And then having Vicky and Antifan providing assistance on different matters is helpful. And the work of the investigations committee tends to, there's a whole lot at once, and then you're sending it off to the investigators, and then you're providing guidance to the investigators, and then everything comes back, and then you follow up. So it comes in chunks. So I would say yes, at the moment it's manageable. When we have a number of hearings going at once and investigations and complaints, that will become something that will have to be considered. But right now it is manageable.
Thanks very
Sure.
much.
If I may, just one other question, and mainly for those who are participating but not members of our committees and the board. You mentioned unauthorized practice, and of course by that you mean individuals out there that are holding themselves out as being able to perform the services of a licensed agent. is your role and the role that you play one of simply receiving complaints, or is there any active sort of investigation as to those in the market that are carrying out or holding themselves out as being authorized to practice?
So it's primarily reactive. But when, for example, we often receive information through other staff, through perhaps the process of suspending licenses because somebody hasn't paid their fees and that kind of thing, then we look to see what risks that creates for the public. And one of the things that then happens is that we proactively look at the website and make sure that they are no longer marketing themselves as able to practice, that sort of thing. But tied to your first question about resources, we couldn't possibly go looking. It's a huge problem for sure, but we don't have the resources to be more proactive in that regard. Maybe Judah would like to add.
I would say, though, this is also an area where everyone rows together, and we are working closely with CPO, who deal with 10 different types of scams at any given moment, according to them, as of 2 days ago. They have the IP fraud is rampant. IP fraud is targeting the public in general, as well as existing rights holders. There are scams that are purporting to come from CPO itself, or from other patent and trademark offices around the world. There are other types of scams for example, the ones that we are dealing with. And so what we are doing is we are very well attuned to the scams as they are coming in at this point. We don't have to look for the ones that are targeting where people are holding out as patent agents and trademark agents who are, or lawyers or others who are actually purporting to do the work of patent agents or trademark agents, where it's a true scam and where the public is at greatest risk of harm. Those are coming to us very quickly, and we are doing what we can within our toolkit quickly to address them. So the first thing we do is we name and shame. As soon as we have a name, a new entity, a new phone number, a new address, we put it on our website. And our web page is updated regularly, and we've now added date of update onto that page so everyone can know when this has last been viewed. And then that pops us into Google so that anytime somebody is then doing their own due diligence, once they hear from some purported professional, they see us. And that's been having an impact. We're also sharing that information and sharing practices with CPO and with IPIC and with others through the system. And so we're covering off the higher areas of risk at the moment, which really are the phishing scam.
Thanks for that additional response, Judah. Any other questions for Victoria before we move to our next presenter? Seeing none, Victoria, thank you. That was just an excellent presentation. And thank you for the incredible work that you lead on behalf of the college. So just before I move to our next presenter, I just have to tell you all, earlier I was talking about our new member, Dennis Haskell, who is like, riding a million miles against headwind. Dennis has now joined the meeting. So, wow. So welcome, Dennis. And again, we look forward to meeting you in person. You are a very dedicated board member, and we thank you very much. So moving on to our next report, it's the Pathways to Licensure. So Jen Slobodkin, Director of Registration and Education, and our Deputy Registrar, is going to be talking to us about key findings from the 2024 consultation on pathways and next steps. So over to you, Jen.
Thank you, Madam Chair. I'm very excited to talk about the work that CPATA has begun on assessing the pathways to licensure, specifically the training program. Yesterday, during the annual general meeting, we reported on what we heard during the consultation on apprenticeships conducted last year, where there's room for improvement within the existing frameworks and what changes we're making immediately. I'll provide a brief overview of that presentation. So last year, between April and November, we undertook a broad consultation about the training programs. An independent third-party consultant gathered information from IP stakeholders and licensees about their experiences with and insights about the apprenticeships. The purpose of the consultation was to assess the merits and challenges associated with the 24-month apprenticeship model. And we appreciate the feedback of all of those people and licensees who shared their insights with us through that consultation. I'll briefly describe the 10 key findings and some of the next steps that we're going to be taking to address some of the issues that were identified. The first key finding was that the greatest barrier to licensure is an inability to secure an apprenticeship. To address this as a first step, Class 1 and Class 2 agents who are open to supervising a Class 3 agent in training will soon be able to indicate so on their CPATA profile. In turn, Class 3 agents in training who are looking for a supervisor will be able to indicate that on their CPATA profile. This information will then be visible and searchable on the public register. We recognize that this is one small step to help connect those seeking to apprentice with the professions, and we'll be continuing to explore how this and other IP stakeholders will be able to help bridge the gaps between those interested in entering the professions and those open to serving as supervisors. The second key finding was that a lack of structured training requirements for intellectual property apprenticeships pose difficulties for both trainees and supervisors, and that guidance was desired by all. To address this, we'll be developing training resources to provide guidance to supervisors and trainees on the training requirements. To support supervisors and trainees develop training experiences that actually prepare trainees for entry to practice, CPATA will be providing materials that may help structure their training and allow for all the knowledge and skills in the competency profiles to be addressed during their 24-month training apprenticeship period. And additional resources will be considered for development in the next 12 to 24 months. The third key finding was that the profession largely views the apprenticeship model as vital. The fourth key finding was that some respondents were open to CPATA exploring education-based pathways to licensure. The fifth key finding was that examination timelines were delaying entry to practice. And to address this, we're revising the eligibility criteria for Class 3 agents in training to attempt the patent and trademark knowledge examinations. Starting with the Winter 2026 administration, Class 3 agents in training who have completed at least 12 months of training under a supervised trainer will be eligible to attempt the knowledge examination if they wish to do so. And as a reminder, the knowledge examinations are just the first part of the examination process. Agents in training must also demonstrate competency on the skills examinations after demonstrating competency on the knowledge examinations. The reduction from 24 to 12 months is intended to help trainees complete the licensure process faster and enter unrestricted practice faster. And the change will reduce the wait times that trainees have had to take between completing their training and entering the examination process. The sixth key finding was that supervisors would like to see training incentives introduced. The seventh was that respondents cautioned against making rapid changes to the licensing process, and we definitely heard that and will be moving very slowly on any next steps to alternative pathways. The eighth key finding was that intellectual property practice should be promoted more broadly to encourage more individuals, including individuals from diverse backgrounds, to enter the professions. The ninth was that key findings were that the respondents identified several metrics that CPATA may wish to use to help evaluate the effectiveness of the current licensing pathway. And the 10th was that clarity around CPATA's role was still required. The changes to the public register, the development of the training resources, and the changes to the eligibility requirements for the knowledge exams will be implemented over the next 12 months. And our hope is that it will help facilitate access to the professions, reduce anxiety around the apprenticeship requirements for supervisors and trainees, improve consistency of training, and reduce unnecessary delays on exam writing, thereby potentially reducing the entry to practice licensure time. Finally, CPATA will continue to reflect on the learnings from this consultation. Agents in training, supervisors, and other IP stakeholders brought up really important considerations that require further reflection by CPATA's board. The consultation confirmed that hands-on training is a vital component of learning the knowledge and skills that are required to be a patent agent or a trademark agent. So the possibility of integrating education-based components to complement or support apprenticeships or to provide an alternative pathway to improve access to the professions will also be considered further. Again, these areas continue to be explored, and no policy decisions have been made as to whether such pathways can or should be implemented. And should such major changes be proposed, we will consult on those changes as well. Thank you, Madam Chair. I am happy to take questions.
Thanks very much, Jen. That was an excellent report. Any questions for Jen? Go ahead, Scott. You know what? We're just going to just send it over to you, Scott. Go ahead.
I'm trying to ask those questions that I think many others have. Just one question suggestion, and that is because of the difficulty in getting people to step up and take on a supervisory role, is it possible to have a kind of a joint supervisor, say a corporation that has a need for intellectual property advice and a firm, so that the responsibilities could be shared between the two?
Yes, and we actually do have some scenarios that are in place right now. We try to be as creative and flexible as possible when we are looking at applications from Class 3 agents in training as well as their supervisors. And there are some agents in training who have supervisors from different areas of the same firm or even from different organizations, so long as the proper conflicts of interest and confidentiality procedures have taken place. And that will allow those agents in training to receive the depth and breadth of training experience that they need, that's covered in the competency profiles, but that they might not be able to get through their sole employer. So we are definitely looking at those types of training structures, and we're going to continue to explore those as well, including IP clinics and other types of environments where people can learn the knowledge and skills that they need to be competent and ethical agents.
That's great. Good question, Scott. That was a good discussion. Thank you. Steve, you've got a question.
Try not to act so surprised. Jen, that was an excellent report. Very quick question, just in terms of putting together or creating the materials for training. I think it was point 2 or point 3. Can you explain a little bit about how you're going to achieve that end? I think I might have mentioned or suggested on a prior meeting, there are some firms that have very good in-house training procedures, also some very good courses that some of the professional organizations offer, including the materials that they have. So just curious about the process that you're going to go through in terms of assembling and putting together those materials. Thank you.
Thank you, Steve. For 2025, we're going to be developing a transitional resource with our consultant that has been working with us on the competency profiles, just so that we can provide something this year for supervisors and trainees to help them track their milestones in training. And then in 2026, we're going to be doing more development work, and we're going to be reaching out to the professions and recruiting subject matter experts, so practicing licensees, to assist us in developing those longer term training resources. Which will include something that they can do right at the beginning of their training to kind of set up their training plan, some interim checks that they can do throughout the 24 months to make sure that they're meeting those milestones and tracking any gaps or anything that they might be needing to fulfill. And then a final kind of summative resource that supervisors can use with their trainees to make sure that they've covered all of those areas before attempting the skills examinations. So we will be reaching out to the professions to ask for some assistance in sitting on working groups to help us develop those resources. And I'd be happy to have anybody from the professions assist us with that. So thank you.
That's great. Thanks very much. Thanks, Jen. All right, I'm looking around the table. I'm not seeing any more red lights on microphones, so I think we're good. Thanks for an excellent presentation. Thanks to directors for your engagement in this important initiative. Next up on our agenda is the appointment of the auditors. And so there is a motion that will be tabled, but prior to that motion, Sean or Judah, did you want to provide any introductory comments, or do you want me to put the motion on the table? Okay, I'll put the motion on the table and then we'll have discussion. The motion, be it resolved, the board reappoints Joan Grant Thornton LLP as external auditor for CPATA's 2025 year-end audit. Could I have someone make that motion, please? Elise, thank you. And a seconder? Steve, thank you. The motion is now on the table. So I'll open it for discussion. Judah, Sean, Bob, is there anything you want to add? No, it's just, that's pretty much, there you go. There's the motion. All right. Any discussion on this motion? Again, we've all received the package and have read it. So with the motion on the table and seeing no further discussion, I'll call for a vote. All in favor? Any opposed? That motion is carried. Thank you. All right, next up, we have a revised travel and reimbursement policy. Again, there's a memo from the Audit and Risk Committee with the revised policy and track changes, which were in your package. So again, I'm going to put the motion on the table and then we can open it for discussion. Be it resolved, the revised travel and reimbursement policy is approved and the CFO is authorized to update Appendix A as necessary to reflect the Government of Canada's Treasury Board mileage rate and the CRA for the meals and incidentals rates. That motion, who would like to make that motion? Thanks, Scott. Scott is making that motion. May I have a seconder? It is seconder, perfect. That motion is now on the table. Again, you've received a memo and all of the information in your package. Is there any discussion or questions? We do have our CFO and chair of our audit committee here if there are any questions or discussion. Anything additional you'd like to add? Bob, Sean? No, we're good?
Maybe just a brief. So just the, really the whole nature of this is just to take the actual rates out of the policy and put them into an appendix. When this was drafted last year and a half ago, my intention was that we would just update the rates, but never dawned on me that we'd have to update the policy at the same time. So this is just correcting that and taking it out so it's much cleaner and quicker.
Yeah. So the appendix can just be updated as required based on those two reference points in the motion, and then we don't have to reapprove the policy over and over again.
Exactly.
So that's perfect. All right. So that being said, any other discussion or questions? I'm going to call for a vote. All in favor? Any opposed? The motion is carried. Thank you. Thanks, Sean. Thanks, Bob. Thanks, Judah. All right, next on our agenda is other business. And when we did our agenda approval, no one had brought forward any other business. So I'm looking around to see any hands raised. All right, with no other business, I will formally adjourn this portion of our public meeting, and the board and its committee chairs can go in camera. So thank you to everyone who participated with us online, and thank you to the management team for an excellent board package. Thank you to all of our presenters, and the meeting is now adjourned. Fine, we'll do a motion to adjourn. Okay, then. Could I have someone make a motion to adjourn the meeting? Karima, thank you. And is there a seconder? Amber, any discussion about adjourning the meeting?
I would like this meeting to go on forever.
All right. All right. All in favor? Any opposed? The meeting is adjourned and the motion is carried. Thanks all.